What's going on, guys? Nick Boutwell. It's our ethics class, and we're rolling into week 5. We're almost done with this class, and we're tasked this week in week 5 of presenting a YouTube video or PowerPoint about the adversarial system of criminal law based or compared and contrasted against another law practice, and I picked the equestrial system. Um, the adversarial law is what we as United States citizens were used to. Um, Equestrial system is more of a Roman law, very European, and with us and Europeans being so similar, and a lot of the things that we do are so similar. Our Constitution is based off of the French Constitution. We speak the same. Us and the British, we speak the same language, and our criminal justice system mirrors each other. But then, if you look at the British, they do some things that are kind of different than what we're used to. Whenever it's based off of rights and right to remain silent and stuff like that, it's more of an equestrial system. They're more mixed than we are. The French are very equestrial with their systems. The Germans, the equestrial system is very European. Um, the adversarial system is what we use and what we've come to know and what we think is a very fair way of deciding criminal law and decisions and judgments. And then other countries have also adapted to that adversarial system, uh, like Australia, um, New Zealand, um, more of westernized countries, if you will. There's some similarities between the two, and there's a lot of differences between the adversarial system and the equestrial system. Um, the adversarial system is more of a common law. Um, it's based off of evidence. It's not based off of testimony. It's based off of evidence. Um, so with the adversarial system, you have two opposing parties. They come together in a court of law, and they argue the prosecution and the defense. Prosecution says this is what happened. The defense says this is what happened. Um, according, I went on the Grantham University Library and I pulled this article called "Now You Think You're a Lawyer." Now you're thinking like a lawyer. It quoted by saying, "What the adversarial system does is pit two sides against one another, with self-interest motivating their lawyers less towards the pursuit of truth and justice than towards the pursuit of victory. Between the lawyer stands a judge who, in the dominant tradition of American law, is not a seeker after truth or justice either, but rather a neutral referee seeking only to ensure that the combatants obey the rules of fair play." And that is by Michael Kinsley, and the description or the citation will be in the description of the video. So let's look at this. Let's look at this quote. It says the adversary system does not pit, or does what the adversary system does is pit two sides against one another. That goes back to the two opposing sides. The adversaries, the prosecution and the defense. The prosecution is wanting to win and get a judgment for their side. The defense is also wanting to win to get their client or the offender less jail time, no jail time. Try to get a hung jury, do everything that they can to try to get that person off and not have any kind of jail time, maybe have probation or something like that. Let's keep going. With self-interest motivating lawyers less towards the pursuit of truth and justice than towards the pursuit of victory. Now this goes back to me, I think of defense attorneys whenever I read this quote. With the self-interest of motivating the lawyers less towards the pursuit of truth. So the defense attorneys don't want to know what the truth is. A lot of them will be like, "Look, man, don't tell me that you did this. I'm here to fight to make sure that you get a fair trial and that you get off. I don't want to know what the truth is. I just want to make sure that I'm giving you the best defense for your money." The prosecution does the same thing. They're more worried about their stats and their conviction rating compared to if this person actually did this. In our I'm also taking a criminal procedure class. And our assignment for this past week was the Innocence Project, and that goes back to eyewitness identification and law enforcement and prosecution leaning more towards eyewitness testimony because they knew they were getting convictions based off of DNA evidence. Now, granted, DNA evidence wasn't really that popular then whenever these people were getting convicted, but eyewitness testimony played a lot in convictions. And as you see, I'm a law enforcement officer, and what they used to do back then was wrong. Between the lawyer stands a judge, who, in the dominant tradition of American law, is not a seeker after truth or justice either, but rather a neutral referee. All the judge is doing in this, yes, they're saying this person is guilty, and this person they judge this person for what they did based off of evidence. But during the whole criminal proceedings, they're a referee. You take a normal criminal trial. All the judge does is say, sustained, overturned. You can't say this. This is hearsay evidence. They make sure that no party is getting away with too much, if that makes sense. And then the jurors are the ones that actually decide if the person is innocent or guilty. Another thing with the adversarial system, there's a chance for cross-examination. So if an eyewitness gets on the stand and says, this person did this, I saw this person do this, the defense can come and cross-examine that witness and say, are you sure that you really saw this? The biggest thing about cross-examination is they're trying to either to see if that person is reliable or not, and see if their eyewitness is reliable. The burden of proof whenever it comes to the adversarial system in a criminal trial, and civil trials are a totally different thing. With criminal trials, the burden of proof is based on the prosecution, and their burden of proof is beyond a reasonable doubt. With the defense, it's strictly based off of placing doubt into that jury, into that judge, and as soon as they place doubt, it's done, and your case is over. One of the biggest negatives whenever it comes to the adversarial system is the long delays. Whenever you think about the inquestial system, there's no delay. It's quick, it's fast. With the adversarial system, we go from point A, which is the crime happening and law enforcement being called, to point B, which is judgment. It could be 6 or 7 months before you see this. I know whenever I left the department that I am to go work for the state of Georgia as an investigator, a year or two after I left, I'm still getting cases from whenever I worked at my police department, and having to go to court for that. So it's a very lengthy process. Now with the inquestial system, it's different. It's very quick. It's very fast. It's very straight to the point. With the adversarial system, we think about our fundamental rights as United States citizens: the right to a fair and unbiased trial, the right to you think of the Fourth Amendment, the right of unlawful search and seizure. You think about the right against self-incrimination, pleading the Fifth, the right to remain silent. With the inquisitorial system, you don't have these basic fundamental rights. What will happen is a crime occurs. Law enforcement gets called. The police get there, who have very little power in this system. What will happen is an investigating judge, is what they call it. An investigating judge comes to the scene and they run the entire investigation. They tell police where to go. They tell detectives where to go and what to do. They collect evidence. They interrogate witnesses and suspects. The judge investigates suspects and witnesses. Once the judge feels like this person did this, he'll present it to the prosecuting judge. So you got to think, we got a judge who is probably good friends with that other judge, presenting evidence to this judge. So I got this quote off this article. It says England limits the right to silence and moves towards an equestrial system of justice. It states the development of the right to remain silent, which is a basic principle that we have as an American citizen, in England, spanned hundreds of years, with the intent, with the tied to the great struggle between rival systems of criminal procedure, the equestrial common law courts and the equestrial ancestral courts. These systems were fundamentally divided on a key method of investigation and adjudication. Reliance of the accused to furnish testimonial evidence of their guilt, the common law courts this method and came to rely primarily upon independent evidence. By contrast, confessions with the essential component of the equestrial system. So, the equestrial, pretty much out of that whole quote, the biggest thing that I got says the confession is the essential component of the equestrial system. So this judge will go in and he'll get a confession pretty much by whatever means is necessary. You know, now granted they're not, torturing people, stuff like that, but coercion, intimidation that we base our whole investigation are based on not doing this. Whenever you get your Miranda, there's a portion. Whenever I read somebody Miranda that says you're not being coerced, you're not being threatened to be here to talk to me. After we go through you have the right to remain silent. Anything you say can and will be used against you in the court of law. You have the right to an attorney. Yada yada yada. At the end of it, I add an extra sentence that says you're not being coerced or threatened to be here and talk to me. This is completely voluntary. They don't have that in this equestrial system. The judge will go in and interrogate somebody for hours and hours and hours and hours to get a confession, and that is based off of their entire thing. Law enforcement works very closely with the judge in collecting evidence. Also, in the equestrial system, the judge and law enforcement can hold somebody up to 48 hours without ever pressing charges on that person. So they'll take somebody, they'll interview them for hours, throw them in a holding cell for 24 hours, interview them again, put them in a holding cell for 10 hours, do it again, interview them again, so on and so forth. And it could be a 2-day interview process, 3-day interview process. The strongest minds will break after that point, and it's downright coercion. During the proceedings, during the actual trial phase and in the equestrial system, the judge, the prosecution does not interrogate. They don't question witnesses and the accused. The judge does this. The prosecutors are pretty much there just as a figurehead during the proceedings. The judge interviews everybody. Also, in something in the American legal system, in the equestrial or the adversarial system, is that whenever hearsay evidence in the equestrial system is admissible in court, you can bring that into court. And what hearsay is I heard this person say this, and that is admissible in the court. Now, in the adversarial system, that's not admissible in court. You cannot use hearsay evidence. The burden of proof, whenever it comes to the equestrial system, is very low. The burden of proof is very low in the equestrial system. It's not beyond a reasonable doubt, and I believe that has to go back to when the judge's relationship with each other, the investigating judge and the prosecution judge. The burden of proof is solely on the defendant to say, I didn't do this. You have to prove why you didn't do this. In the adversarial system, the burden of proof is on the prosecution to prove that this person did this. I like to say with the adversarial system, think about a DUI arrest. A DUI arrest, especially in the state of Georgia, is the only law where the prosecution is saying that this person's innocent based off of this. So we do tests. We do field sobriety tests. to prove that you are not under the influence of alcohol. So it's pretty much the same system. So I hope this enlightens everybody a little bit on the difference between the adversarial system and the equestrial system. And thank you.